will speak about the jurisprudence mainly of the court of the last about 12 months. Maybe there are participants among you who participated or the last year. Last year I had a presentation with a very similar team which was done beginning, it was towards the end of November, so I choose now the period between November last year and November this year and selected a couple of judgments which, in my view, seem to be important and relevant for anybody who would like to know what happened in these 2 months. I will concentrate my presentation on judgments of the Court of Justice. Now, you might wonder, because I'm judge at the General Court, that I'm concentrating on that, but it seems for me necessary to do so because last year I presented a number of judgments of the General Courts which have been annulled in the meantime. So I'm somehow then doing something and explaining you some decisions of the General Courts which do not have standing on the long run, and that is a bit sad, and therefore I try to do something different, try to concentrate on those judgments which cannot be changed anymore. But you will see, of course, that even in the case of judgments of the Court of Justice, sometimes it happens that the Chamber of Five decides quite differently as compared to the coherent previous jurisprudence. We will have at least one case, the case Frukona-Košice, in which, in a very recent judgment, which came out a couple of days ago, a Chamber of Five decided something which cannot be really harmonized with the standard jurisprudence, in particular with the judgment in the very famous EDF case. But let's start with some formal questions. First of all, I would like to say that on 21 December last year, there were 5 very important judgments. One of them is the case of Club Hotel Loutraki, which came out on 21 December. There will be 4 others which I will report about, which by coincidence also were published on 21 December last year. But there are also judgments which are quite recent. I will deal also with judgments which just came out yesterday. The TV2 Denmark cases, which seem to have also some importance in regard to the case law in state aid. Well, Club Hotel Loutraki concerned actually something which at first sight didn't seem to be a case of state aid, because what has been notified by Greece in this case was a license to operate 35,000 video lottery terminals. Since this was an exclusive license, Greece thought it is wise to notify that as state aid and to obtain an approval of the Commission. Of course, all the competitors working on the same market were upset about this. They would have liked to participate in the business, which was excluded. Therefore, they were opposed and complained, and also took part in the procedure, the formal procedure the Commission initiated. In this case, there was no formal investigation procedure, so the participation was more or less informal by way of complaints. And that has been attacked by the competitors before the court, General Court, and later on there was an appeal before the Court of Justice. So the question discussed in this case was it possible to take a decision, a positive decision, on the basis of a phase 1 procedure? You know that generally the Commission, in about 97% of the cases, takes positive decisions on the basis of a very simple phase 1 procedure in which there is no opening of a formal investigation procedure, and only in 3 of the cases, the Commission takes decisions on the basis of a formal investigation procedure opened by a separate decision. The court underlined this procedure and underlined also the possibility to have investigation based on a phase 1 procedure, which is perfectly okay even in cases in which the procedure has a duration of more than only a couple of months, like in this case where the negotiations with Greece lasted for about 10 to 11 months. This kind of phase 1 procedures is foreseen in the procedure regulation. The old one was 659 from 1999. Now we have another one, 2015, 1589 is the number of the new procedure regulation. But in the cases I'm reporting about, it was the old one which had to be applied. Now the great question in all such situations like the Loutraki case is, what are those elements in a state aid investigation which force the Commission to open a formal investigation procedure? And that is very difficult to be described in an objective manner. The court didn't do it, by the way, in the Loutraki case. It just underlined that only if there are objectively doubts about the compatibility of a measure, the Commission is obliged to open a formal investigation procedure. Now, the expression that measure notified should objectively have raised doubts is somehow an interesting formula, because doubts are always extremely subjective. So to say that measures notified should objectively have raised doubts is somehow complicating issues without any real need. It would be much more important if the court could establish those criteria which are there in the case of doubts. So what makes doubts actually doubts objective? That is still not clear on the basis of the jurisprudence, but I can tell you that in my view, there are certain situations where certainly an opening of a formal decision, investigation procedure must be done, and that is if there are any kind of arguments in regard to the compatibility of the measures investigated which go in the direction of infringement of basic principles of union law, like non-discrimination, or which go in the direction of infringements of fundamental freedoms. That is, of course, not very often the case, although more and more cases of this kind do appear in front of the Commission. And we will see that in certain judgments, the court tries to establish a quasi-relationship between selectivity and discrimination, and appears to consider selectivity is only given, and selectivity is a main element of the notion of state aid, if there is a kind of discrimination. The problem is that a state aid necessarily must be selective, otherwise it's not state aid. If it is linked to discrimination, then it cannot be approved. So I don't think that the court's argumentation in that regard is correct, but we will come to that later. So in case Loutraki, although it was disputed very much whether the Commission should have opened a formal investigation procedure, the decision of the court did not really clarify the questions. It rejected the arguments of Loutraki and the other competitors of the license holder. It also underlined that there is no clear relationship between the necessity to open a formal investigation procedure and the duration of the phase 1 procedure. Why is that important? That is very important because of further rights of the applicant in case of an application before the courts. In the case of a phase 2 decision, where the Commission adopted a decision on the basis of information collected in the framework of a formal investigation procedure, an application can only be successful and admissible if applicants can clearly demonstrate that they are individually and directly concerned in terms of Article 263, fourth paragraph. That is not the case if the Commission took a decision merely on the basis of a phase 1 procedure. In the case of phase 1 procedure, any interested party, not only competitors, any interested party can admissibly attack the decision of the Commission by simply arguing that it lost its possibility to comment on the case, so that procedural rights of these interested parties have been infringed. That's a huge difference. So, in a certain way, the court, in its jurisprudence, and I refer in this regard to a series of judgments confirming this line, according to this jurisprudence of the court, 263, fourth paragraph, with the necessity to be individually and directly concerned, does not apply. Very curious result, but that's the jurisprudence. Well, another judgment of 21 December 2016, the case Hansestadt Lübeck, concerned a judgment of the General Court which annulled the Commission decision to open a formal investigation procedure in regard to a tariff schedule of an airport in Lübeck. Lübeck is a city in the northern part of Germany. According to this tariff, or according to the decision of the Commission, which was attacked and annulled by the General Court, the measures consisted in a very favorable tariff for one single airline. I don't have to mention which one, because there is only one which profits from all these very favorable schemes. That's Ryanair. In reality, the scheme was not specifically designed for Ryanair, but by coincidence, Ryanair was the only airline which used the airport. So whenever there are general tariffs and apply only to one client, it is clear that in a certain way that could be seen as being selective. In this case, there was an initiation of a formal investigation, after which the Commission decided that the measure is, first of all, state aid, because it does favor one single enterprise, so it is selective, and it also decided that the measure was not compatible with the internal market. Of course, the airport concerned and the city concerned, Lübeck, attacked this decision. The General Court annulled the decision of the Commission. The Commission presented an appeal, and in the framework of this appeal, the Court of Justice had the possibility to express itself on the subject. And in the framework of this judgment, the Court of Justice just stayed with its traditional case law and decided, whilst it cannot be ruled out that a measure by which a public undertaking lays down the conditions for the use of its goods or services is selective despite applying to all the undertakings using those goods or services, it is necessary in order to determine whether that is the case to have regard not to the nature of the measure, but to its effects. This is a traditional jurisprudence saying it is not the form of a measure, but the effects which count. Of course, also not applied in all cases, but that should be actually the general traditional view. By examining whether the advantage which it is supposed to produce in fact benefits only some of those undertakings as opposed to others, although in the light of those objectives pursued by the regime concerned, all of the undertakings are in a comparable factual and legal situation. And this is the judgment I mentioned in my initial remarks, in which, in point 53, the Court of Justice underlined that the concept of selectivity, as the Advocate General in this case underlined, is somehow linked to the concept of discrimination. That is a very curious and very problematic constatation. It is not decisive for the judgment. It is not the basis of the decision which I quoted before. But it means that the notion of state aid is necessarily always linked to the concept of discrimination. But the principle of non-discrimination, according to the standard jurisprudence of the court, is a general principle of union law, and there is no way, in terms of the old jurisprudence, starting with Janelli and Volpi, and so a number of about 12 to 13 cases, it is impossible to approve state aid which is contradicting general principles of community law. So this aid should not be taken seriously. The phrase in point 53 of the judgment is not. Now, the judgment in case Lübeck is a judgment which concerns merely the question, is a measure of that kind as put into effect in the case of the tariffs of the Lübeck airport selective or not? And the decisive question to be replied by the court was, in this case, what is actually a general scheme and what is an exception which has to be justified particularly? Normally, it is the member state and the regulation which is valid in a member state which is considered to be the general scheme. And any kind of departure of that, any kind of differentiated regulation is then the reason why we have a selective and favoring provision. In this case, the question was, is the territory of the Federal Republic of Germany, which is pertinent and which is the level at which we have to look what is the general measure, or does any owner of an airport has the possibility to have its specific tariff scheme, and therefore a differentiation has to be established within that tariff. And the court decided that this second concept should be applied. So any airport can have its tariffs. It is not allowed to differentiate. That was not the case in the case of the airport Lübeck, at least not formally. Therefore, no selectivity established in this case. The next case, which also concerned selectivity and was also published on 21 December 2016, all those participants who were here last year might remember that I reported already on that case because it was pending and we had already an opinion of Advocate General Vatelet in this case. There was in Spain a very interesting tax scheme which favored investments, in particular share acquisitions of companies outside Spain. It was absolutely clear for the Commission, as long as it concerns acquisition of shares of other companies within the Union, the case cannot be accepted. So the question, which was then largely discussed, and Spain accepted that, was whether investments made in third countries is also to be considered as establishing selective measures and therefore state aid. So, to describe very shortly the scheme was in the corporate tax legislation. It foresaw that acquisition of shares in a company established outside Spain can be deducted from the taxable income base as soon as it was an acquisition of more than 5% of these shares. What was the background? That is not clear from the judgment itself, but for anybody who knows how it works. Spain, by coincidence, has a language which is spoken widely in South America. Therefore, there are lots of Spanish enterprises which try to enter the market in Latin America. Spain has wonderful know-how in constructing of motorways and highways, of constructing water reservoirs wherever, and therefore has very good chances to develop a market in South America, and the measure at stake here should promote these activities. So that is the economic background of what was happening. Now here again, the question was, is a measure of this kind selective? The General Court, in its judgment, considered there was no selectivity. There was no selectivity. Why? The argument was that the measure is just a general provision which applies to everybody. Whoever would like to have an investment abroad can profit and can deduct this investment from the taxable base. The Commission appealed, and in the appeal judgment, the Court of Justice had a completely different view. It said it is not necessary to compare enterprises which profit from this measure to those which do not profit, and it is not necessary to establish clearly the criteria for building these two separate groups, because there is no way to establish criteria which make a clear differentiation. So, what is important is to see whether there is a criterion on the basis of which there is a clear differentiation between enterprises favored and those which are disadvantaged, and that is the case here, and that is the case on the basis of two criteria. First, an investment made in Spain is not privileged, while an investment outside Spain is privileged and favored. Therefore, there is a selectivity. Second, an investment of less than 5% is not privileged. An investment of more than 5% is favored. Therefore, there is a second element of selectivity being one of the main criteria among the 5 of the definition of state aid in Article 107, first paragraph. So, as I said, and I will read it out because that is a very important phrase, I think, according to the court, it is sufficient in order to establish the selectivity of a measure that derogates from an ordinary tax system to demonstrate that the measure benefits certain operators and not others, although all these operators are in an objectively comparable situation in the light of the objective pursued by the ordinary tax system. What is the objective of the ordinary tax system? Favoring investments in other companies or acquisition of shares in other companies. And what is the measure here? It favors only certain types of acquisition of shares, not others. In particular, no acquisition of shares within Spain. And as mentioned, and that is in the last bullet point, there was also the 5% threshold, which made up a second element of selectivity. Well, I come now to another judgment which was delivered on 21 December 2016. This is Vervloed. This is a very interesting case, a Belgian case which concerned some cooperatives established in the financial sector. The basis of this case was a preliminary ruling request coming from the Constitutional Court of Belgium. And it concerned the interpretation of the Directive 94/19 EC on deposit guarantee schemes, and it concerned also the question of whether the measures foreseen in the Belgian legislation constitute state aids. You know that in the framework of the first economic crisis already in the past century, member states had, on the basis of the directive I mentioned to introduce legislation on the protection of deposits in banks. The total amount protected was 100,000 euros per person. Now, Belgium did not only protect it by the measures at stake here, deposit holders, but also investors in a certain way. Investors means shareholders in cooperatives. One of these cooperatives was the ARCO group, which consisted of several cooperatives working independently, and the shareholders of these cooperatives had a protection very comparable, very similar to those of deposit holders. That is, first of all, not foreseen in Directive 94/19, and the question was whether the directive allows that. The court's reply was, it is not foreseen, not necessary, but it's also not excluded. And then it came to the second question, is that scheme protecting shareholders, not deposit holders, it's a huge difference, a state aid? That was disputed. The Commission was of the opinion, yes, it is, and there was already a decision in which the Commission committed itself to this point of view, on this opinion, and therefore this decision was a negative decision which obliged Belgium to recover the money. That did not happen, but the question was also, is that decision void? And in its reply, the Court of Justice stated that the measure does constitute state aid. The question to be replied here is, are the beneficiaries in this case, the shareholders, are they undertakings in terms of the definition of state aid in Article 107, first paragraph? And the reply was, they are not, because they are consumer natural persons, which are not necessarily involved in business activities, but not only the shareholders profited from these measures, from these guarantee schemes for shareholders, because the guarantee made it possible to them to keep their shares and their participation in the cooperatives. The cooperatives were at the same time the main shareholders of Dexia, a very important bank. Therefore, the measure benefited also the undertakings bank Dexia and also the undertakings financial cooperatives within the group ARCO. And these side effects make the measure therefore state aid. They therefore had to be notified. That was not the case, so that the state aid was illegal and, as the Commission established, incompatible with the internal market. So via the protection of undertakings like ARCO and Dexia, the measure became aid. There is a judgment of the Court of Justice which goes in a similar direction, which I didn't mention on my slide. It is the case C-194 from '98. In that case, there was a tax scheme in Germany which favored investments in companies established in the new Länder after reunification of Germany. In that case, the direct beneficiaries of the tax exemption foreseen were those who invested, so shareholders. And in those cases, it was also disputed whether the measure, in the light of the fact that the direct beneficiaries are just natural person, be considered to be state aid or not. And there, the arguments of the court went in the same direction. Actually, not only shareholders profit, but also all the enterprises in which shares have been obtained, and these enterprises necessarily had to be according to the scheme in Eastern Germany, are also benefiting. They are undertakings, therefore the measure is to be seen as state aid. So now we leave the judgments from 21 December 2016 and come to another interesting judgment which came out this summer, and it concerned the Congregación de Escuelas Pías Provincia Betania in Spain. This was also a preliminary ruling case by which a Spanish court asked the Court of Justice to express itself on a tax provision which exempted certain Catholic organizations from certain taxes. In this case, the question was, are these Catholic groups, enterprises like the Congregation, are they undertakings for the purposes of Article 107? Because if that is the case, then the tax exemption at issue is a selective economic advantage. It is also granted by state, because necessarily legislation is a state activity. And it is also evident that in this case, all the definition elements of 107.1 are fulfilled, and therefore the measure also can affect trade between member states and can threaten to distort competition within the internal market. In this regard, also, there is a very long line of pertinent and coherent jurisprudence of the court, which started with the Pavlov and Heiser cases already in the late 90s, in which the court expressed itself on the question of what is actually an undertaking. And the court applied always a very broad definition of undertaking. So it is not relevant whether this undertaking is public or private. It is not relevant whether there is any kind of profit to be achieved. The question is whether there is an economic activity on a certain market. It is also not relevant whether it is free of charge or not. But remuneration, of course, is a very strong sign for the existence of economic activities. So in this case, it was quite easy for the court to apply its traditional coherent jurisprudence on the notion of undertaking and economic activity. And finally, the court came to the conclusion that it is to the national court to establish whether the activities of the Congregation are really fulfilling all the requirements of an economic activity, but if that is the case, then there is a scheme which should be considered as foreseeing state aid. Now I come to a case which is very interesting, which was delivered a few weeks ago, which is Frukona-Košice. In case Frukona-Košice, I reported as well last year already about the judgment which is quoted here of the General Court of 16 March 2016 in case T103-14. In that case, the General Court expressed itself about certain issues, like, for instance, whether Frukona-Košice as an enterprise can, before a court of the Union, argue that the state's rights to express itself in a case like the present case, whether it can say that the state had no possibility to express itself, and the court decided no, but there were other disputed questions as well. In particular, whether the private creditor test had to be applied in this case. The story behind this case is that Frukona-Košice was unable to pay taxes, and it was therefore in a kind of a liquidation. In this procedure, there were agreements with all creditors that only a part of the debt had to be paid. Among others, also the state agreed to renounce. So the state agreed also to renounce to certain amounts. The argument of Frucona Košice was that the state, Slovak state, in this case behaved like any kind of normal private creditor. Had the state insisted that all the taxes have to be paid, that would have meant an insolvency and the liquidation of Frucona Košice, with the result the state gets nothing. In the case of just renouncing 50% of the tax debt of Frucona Košice, the enterprise or the undertaking could survive, and therefore it was a normal activity of any kind of private creditor. Interestingly, this argument was not put forward by Slovakia, and it was not put forward during the procedure before the Commission. So the administrative procedure was conducted on the basis of totally different arguments. The first time that this argument came up was in front of the General Court, and then again after the General Court's judgment has been appealed by the Commission in front of the Court of Justice. Interestingly, the Court of Justice decided here that in any situation of this kind, in which there is an argument concerning the behavior of a private creditor, the Commission is automatically obliged, and on its own behalf, whether what happened could be an activity or a behavior of a private creditor. So it is the Commission's obligation on its own behalf to investigate whether measures of the type at stake in the case Frucona Košice could be seen as not being state aid because a private creditor would have acted in a similar way. This is very new, very, I would say, revolutionary, and it is not really compatible with the traditional jurisprudence. In case Frucona Košice, it was a chamber of 5 judges which decided, and it's totally departing from the substance of the EDF jurisprudence, in which the court a couple of years ago decided that any kind of private investor test and any kind of private creditor test can only be conducted by the Commission if the member state submits sufficient data demonstrating that all the necessary investigations by the state concerned have been done already during, before the administrative procedure and before granting any kind of advantages. In Frucona Košice, there is nothing like that. Nobody thought about a private creditor before alleviating the tax burden of Frucona Košice, but still the court came to a conclusion which is quite surprising and as I said, not really in line with the traditional jurisprudence established by the Grand Chamber. Well, now an interesting German case again concerning Belgium. Belgium reimbursed the costs of a BSc test to farmers in Belgium, which was considered to be state aid. The case was disputed, it was attacked, the decision of the Commission was challenged before the General Court. The General Court decided it was state aid and it was not compatible. That was challenged before the Court of Justice. The Court of Justice confirmed the judgment of the General Court, but then nothing happened, and Belgium did not comply with the decision of the Commission, which became definitive, and did not reimburse, did not try to collect the costs of the BSc tax from the farmers concerned. Therefore, there was a new case against Belgium based on an application of the Commission, which insisted that the decision has to be respected. In this judgment, the Court of Justice reiterated its old jurisprudence, according to which there are only 2 cases in which a non-execution of a decision of the Commission can be accepted. One is if it is absolutely impossible. We don't know what that means, but in reality there were no cases of absolute impossibility up to now, except in cases in which the beneficiary just disappeared from the market, and because it is not existent anymore, of course, no recovery of the state aid granted is possible. And the second case in which it is possible to invoke the impossibility is if the decision, which is the subject matter to be executed, is non-existent. The concept of a non-existing decision comes from a very old jurisprudence of the court from the early 90s, in which this was established in a case concerning a decision of the Commission on BASF, a German chemical industry company, in which it was not clear whether the decision, which was not really advantageous for BASF, has been not really adopted by a Commission, not really signed by any member of the Commission, and it was really very dubious whether there is any kind of decision of the Commission in that case, and these jurisprudence should be applied in the case of a non-existence. But of course the criteria were here not fulfilled, because there was a decision of the Commission, which was clearly a decision of the Commission, which established that the state aid was not compatible, that it is the farmer who has to bear the BSc test costs and not the member state. This decision became definitive because the appeal before the Court of Justice was not successful, and therefore the court had to establish that Belgium did not respect its obligation to execute a decision. There was another judgment of the Court of Justice in a very recent judgment on the question whether existing aid or new aid is at stake in this case. And that concerned Italy, and it concerned a case in which Italy was allowed by a council decision, which is quite seldom applied in state aid. According to this council decision, Italy was allowed to pay the levy of more than 1 billion euros for exceeding the milk quotas by Italian farmers instead of the farmers. And that was foreseen in an Italian law, which then foresaw that in a quite long period between 1996 and 2002, these amounts have to be recollected from the farmers. By an act which was never notified to the Commission, Italy decided to defer certain payment dates on its own, and that was considered by the Commission as being an infringement of the decision of the Council in this regard, and that was established by the General Court and later on also in the judgment quoted here. The court arguing that the simple deferral of payment to the farmers concerned, which was classified by the Commission as new and illegal aid, because the deferral cannot be seen as an alternation of a purely formal nation. So you see, even a deferral of payment in situations like the one I described can constitute new aid and is not a pure formality which does not change the character of an existing aid. On the recovery of aid, there was also a judgment, which was also a judgment of 21 December 2016, on a scheme which I reported about also last year, and I already mentioned that in my view the judgment of the General Court in this case is wrong and will probably be annulled, and that happened really on 21 December 2016. So in this case there was a special tax on air tickets of 2 euros for flights up to 300 kilometers and of 10 euros for other flights. This measure, which had differentiated between long long-haul flights and short-haul flights was clearly favoring those airlines which had their main activities in Dublin or on other airports in Ireland, and that were Aer Lingus and Ryanair. The Commission decided that this is a state aid and that the face amount, the difference between 2 and 10 euros as special tax on air tickets, has to be recovered for these companies. The General Court was of the opinion that that is not the case, that the argument of Ryanair and Aer Lingus is correct, that they pass the advantage they obtained by paying only 2 euros instead of 10 to the consumers, to the passengers, and therefore it would be unjustified to collect from them the face amount, the difference between 10 and 2 euros. That reasoning was evidently wrong. In this case, the general jurisprudence on recovery of taxes which are not compatible with union law does not apply, because there is no way to argue, as argued in all these cases, that there could be then an unjust enrichment. In the case of a state aid measure, it is always the face amount of aid which is favoring, which is therefore to be corrected. The notion of state aid is an objective notion, therefore it doesn't count what was the individual real advantage at the level of the companies. Even if they had the possibility to pass the lower tax, the difference of 8 euros, to the passengers, it was an advantage. Even to have the possibility to sell tickets a bit cheaper is an advantage, and therefore established by the court in its judgment of 21 December, it was necessary to recover the whole amount, and therefore the court annulled the judgment of the General Court. Well, these are now the last slides I have to report on the judgment which was quite recent, Commission versus TV2 Denmark. There, the question again was, is the measure at stake here state aid or not? Does it fulfill all the criteria of the notion of state aid as established in Article 107, first paragraph? And the question concerned exclusively revenues obtained by TV2 Denmark on the basis of advertisements, so the fees for advertisements. In this situation, there was a company, TV2 Reklame, which collected these revenues. The revenues were then transferred to TV2 Denmark via a fund which was established, Fond TV2, and Fond TV2 transferred them to TV2 Denmark. So the situation was here quite complicated, but it meant simply that there was a specific fund which was active, and the question was, is that in view of this construction still a state aid? And the reply was done on the basis of a very old jurisprudence which is certainly well known to you, which is the Preußen-Elektra jurisprudence. And the question therefore had to be replied whether the state had any possibility to influence the decisions of the Fond TV2. That was the case, and it was not to be examined whether this influence of the state, Denmark, was also exercised. The mere possibility to have influence on the distribution of the money via an institution established by the Danish legislation is sufficient to fulfill the criteria of Article 107, paragraph 1 of the treaty. That was the last judgment I had to report on. Of course, I didn't speak about every judgment, and in particular, I didn't speak about a number of very interesting judgments of the General Court, but that is just a consequence of the fact that when I spoke about judgments of the General Court last year and I presented them, this year I had to explain to you it was interesting, but not valid anymore. Thank you very much.